the seller of a property who has been sued for specific performance by a buyer? Are you made a defendant in a suit for specific performance? Are you looking for what are the top three defenses that you can take in a suit for specific performance? If that is your situation, then you're in the right place, because in this video, I'm going to be talking about the top three defenses that you can take in a suit for specific performance. Stick around to the end, because number one is the most effective one that you can take. Hi everyone, my name is Ramana Reddy and I'm a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex legal concepts. For tips, tricks and more legal information, make sure to hit the subscribe button below. Before we get on with the defenses, one thing to keep in mind is that the Specific Relief Act, which is the law that governs the specific performance of an agreement of sale suit, that law has been amended in 2018, and the amendment is fully loaded in favor of the purchaser. So sellers stand at a slight disadvantage than if the agreement of sale was entered into before 2018, for example. In the pre-amendment days, the court had a lot of discretion as to whether specific performance should be granted in respect of an agreement of sale. So as the seller, you could have argued that the terms are unfair, that the property value has gone up many times, and that therefore the agreement of sale should not be specifically enforced. But unfortunately, after 2018, Section 10 of the Specific Relief Act has been amended, and this discretion of the court has been taken away. So in today's world, the courts have no choice but to enforce the agreement of sale, even if the court feels that the terms contained therein are not fair. Having said that, even though that there is a slight disadvantage for the seller, does that mean that there are absolutely no defenses that a seller can take? I don't think so. So here are the top three. The first thing to consider is that don't take contradictory pleas. I mean, the law permits a defendant to take inconsistent pleas, to take alternative pleas, but don't take contradictory pleas. For example, don't say that the agreement of sale is a fraudulent document, but also say that, but there was an oral contract between us. Or say that, that it is a fraudulent document, but the terms are not fair. So which is it? Is it that it is a fraudulent document, or is it that the terms are not fair? Pick one. Speak in one voice. Don't take contradictory pleas, because that will not appeal to the court. It will look like as though you're just trying to wriggle out of the agreement of sale in some way or another, that you're just throwing everything at the wall and see what sticks. So don't take contradictory pleas. Be strategic about it and pick one line of defense and just go with that line of defense. Now, what are some of the pleas that you could take? You could attack the character of the document. You could say that although the document is named an agreement of sale, but if you look at the actual character of the document, it is not an agreement of sale. Take a case where, for example, 90% of the sale consideration is paid as advance and only 10% remains, and the time to repay the amount is 3 years or a very long period. You could argue that, why would somebody enter into such a transaction? I could have just done a sale deed, and the fact that only 90% is paid and 10% is balanced shows that this is more in the nature of a loan transaction. And if you take this plea, make sure that you return the money, because you would be arguing that this is a loan transaction, I have repaid the amount, and so therefore there is no transaction at all now to be, and there's no property that has to change hands. If, for example, no time limit is specified in the agreement of sale as to when a sale deed will be done, you could attack that document and say that, this is not intended to be an agreement of sale. Or if there is no amount that is specified as to what is the total value at which the property will be sold, or the advance amount is not clearly laid out, you could argue that these important critical documents or critical information is not present in the agreement of sale, and therefore it should not be specifically enforced. The number two argument that you could take is that you could argue that there was some fraud or there was some undue influence because of which you were forced to enter into the agreement of sale. You could argue that there were some blank papers that were stolen and so on. But make sure that if you take these pleas, that you actually have the facts to back them up. So because, for example, if you say that a blank paper was stolen, then the following follow-up question will be, well, did you file a police complaint that the paper was stolen, or under what circumstances they were stolen? Now, again, having said that, I would not encourage you to take any false pleas. Make sure that you take some kind of a genuine plea and you come to court with honesty, because generally in cross-examination, courts will be able to see through false defenses. Now, coming to the best, absolute best defense that you could take as a seller, which is the number one thing that you can do in a suit for specific performance, is to argue that the buyer is not ready or that he is not willing to execute the agreement of sale. So readiness and willingness are captured in section 16C of the Specific Relief Act. What you could argue is that the balance money that the buyer has to pay me as the seller, that he does not have that balance amount of money. Even, he could be rich and so on, but he has failed to place on record any evidence to show that he has the money to close the deal, he has the money to pay the balance amount and make me execute the sale deed in his favor. And importantly, he should not only have the money on the date, on, like, say you have 3 months to close the deal in the agreement of sale, not only during those 3 months, but he should have the money throughout the course of the case. So for every single day that the case went on, he should show that he had the money to pay you. So that is to show the financial capacity of the buyer. So that is one thing. The second thing in the top defense that you could take is to show that he is not willing to come forward and close the deal. So what does that mean? Willingness basically means that there has been delay by the purchaser in approaching the court. Obviously, if he comes to court, he is willing to do the deal. We all understand that. But what you are arguing is that if he was really willing to come to court, he would have come to court the very next day. On the 31st of March, let's say that the 3-month period expires, then on the 1st of April, the buyer would have filed a case. But he didn't file it on the 1st of April. He filed it in December, October, November. What was he doing for all these months? It basically goes on to show that he was not interested in doing the deal. And even if he comes at a fairly close date, nobody comes to court the very next day. If the time for performance expired on the 31st of March, then unless he came to court on the 1st of April, as a seller, your lawyer, you should cross-examine the buyer and put his delay under a magnifying glass and see why he came to court after such a long period. And you have to establish that because of this delay, he was not willing to perform his side of the contract. So those are the top 3 defenses that you can take as a seller in a specific performance suit. I hope you found the video was helpful. Thank you for watching.